internship program. During the session, the students will be guided for an overview of career in law, information about basic laws, judgment reading, and legal vocabulary. I would like to take this as my honor to introduce our speaker, who will be our mentor and guide for the next 7 days of this internship program. We are delighted to have such an eminent person with us who has a dynamic legal experience of more than 22 years. Anita Madam started her practice from Andheri Metropolitan Magistrate Court and had done her juniorship for 5 years, which had made her full-fledged litigation lawyer in trial courts. Later on, Madam got exposure to matrimonial disputes, where she did excellent work and was known as one of the leading lawyers in resolving disputes with her enriched experience. Madam have taken a large number of bails and have done more than 2,000 matrimonial disputes. Since last 7 years, Madam have experience as an advocate on record of Supreme Court at New Delhi. Recently, Anita Madam have been appointed on the panel lawyer of Employee State Insurance Corporation at Mumbai in Bombay High Court, and also for CAT, that is Central Administrative Tribunal. Madam have appeared on DD Sayadri channel many times in live session on burning issues of Nirbhaya, as well as other women-related matters. And lastly, I'm very happy to inform you all that Anita Madam is also coming up very soon with a book on legal drafting for junior advocates. Now over to you, Madam. Thank you so much.
Thank you so much, Vandana. Very warm good evening to all. The one topic which interests everybody, that is how to start the practice. And I believe I see some senior faces also here, but then the real effort is to start a practice as a first generation lawyer. Now, somewhere we find it difficult when we are a first generation lawyer. How do we start the practice? How do we get more cases? How do we learn? Now, behind writing a book on legal drafting, my whole intention was that I will be able to present some of my drafting to the coming generation, who will at least have some of the drafting in their hands and the basic draft to understand how to draft a writ petition, how to draft a divorce petition, how to draft the simple applications which are to be made before the courts. Now we write adjournment applications, but it's not as easy as we do in the schools and the colleges we do. It is totally a different era and different arena where we are entering as a legal profession. So always remember that legal profession is not something which is beyond your reach. Only thing, you have to be consistent. If you are consistent, if you are going regularly to the court, you are known by your face, you are also known by the people who are around you. So always remember to go to the court, number one. Number two, try to reach out to senior lawyers, any lawyer which is giving you exposure. If he or she is giving you as a junior, and don't expect the money. And this is a very bold statement when I say don't expect the money, because how do we survive? Now, legal profession, if you all know, it is called as a noble profession. The meaning behind that you have to impart knowledge, you have to help people, and you are guiding people in the legal field. So whenever you are appearing before the court also, we say we oblige my lord. Even if we lose the matter, that is the grace, that is gentleman's job in the court. So always remember that whenever you go to court, the only thing you can learn is keep yourself as a student. First as a student, then as a lawyer. A lawyer is a whole time a student job. Till that, I am not saying because I am sitting on this side of the fence that I know everything. No, it is not possible for me to. There are more than 2,000 laws in India. It is next to impossible to read that in the 5 years course or the 3 years course of our curriculum. Now, always remember that whatever you read is going to reflect in your drafting, in your arguments before the court. So बोलते हैं ना, जो आदमी है वो जो किताबों से पढ़कर आता है वही उसके मुंह से निकलता है. So in legal profession, the basic idea is what you will learn, you are going to reflect in the court. So always remember, whenever you go to the court, it's better you know your brief. आपका जो file है वो आपको पूरा पढ़ा हुआ ना चाहिए. What is the charge? Under what section it is filed? Also, beyond that, what is the matter? What are the facts of the case? Now, facts means the truth of the matter. Whenever you are submitting before the court, you may say the accused has committed this crime, but legally we will say that I'm defending. But you are, as an officer of the court, you have to always remember that what you are speaking before the court is only representing your client's case and under what circumstances happen. There is nothing wrong in defending a murderer or a rapist. But what is wrong is putting up wrong facts before the court, and the judges mind it never appreciate if you wrongly submit. If there is a date, if there is any judgment also against you, if you go through, as you will progress in the session and also in your practice, you will know any judgment which is against you also, some lawyers have cited before court. No, no, this is not the law. This has been settled by the Supreme Court by this way. Today we are also going to read one judgment of Sarla Mudgal, which is also celebrated case of the Supreme Court. Now these are the some milestone cases. I'll be giving one homework every day to read in the group, that you have to read one judgment every day. Now coming back to how do we start practice? Is it necessary we start from Supreme Court, we start from High Court, or we start from only the smallest court, that is the magistrate court? No, it is not true. Court is court. See, if a person has committed a crime, the first thing, if it is murder under 302, he will be taken to magistrate court. So if you always appearing before the High Court, you may not be knowing that what happens before the magistrate court. So always remember that every court you have to attend. And the basic thing, you should become a trial court lawyer first. Those who are trial court lawyer, they are the superstars. The reason behind that, trial court lawyers knows what is the actual cases, and they will be able to argue in any court in India, or I would say even out of the country. So always the trial courts are very important. There are two trial courts. That is one is the session court and one is the magistrate court. Or if you go to the Mofussil area, that is in village areas, you will find there are JMFC, Judicial Magistrate First Class Court. And now we do not have a second class and third class. We only have the senior division, first division, and senior division. So always remember, these are the courts which will prepare you as a lawyer. So try to attend these basic trial course. And even if you don't have any work, go and try to sit there. So it will actually help you to enhance your knowledge, how to represent the case. If your serial number is 10, there are 9 cases before you. So if 9 cases, 18 advocates appear, you will be knowing both the sides. You will be hearing both the sides lawyer. So you will know actually how to speak before the court. You can't say thank you. You say, oblige my lord. I am grateful to the my lord. These are the words. And these are the words we do not use in our regular life. So this is the court language, which you will be knowing only when you go and appear before the court. So the basic thing I will say, wherever you are, whichever place in our country, which is nearest court to you, go and approach that court. Even if any lawyer do not give you any job, just go and sit, observe the proceeding. You will be noticed. There will be cases where the court also appoints the lawyer, that is amicus curiae, or the legal aid center. They will also appoint. There are some clients who cannot afford the lawyer. In those cases, junior lawyers are given chance. So always try to go and appear before the court, sit in the court premises, sit in the bar room. And the most important thing, I would say, try to read a judgment every day. This will prepare you for your future cases. Now you would say, why should I read accident case? Why should I read murder trials? Why should I read any writ petition which is decided by the Supreme Court? The reason behind that, if you read it, it is definitely going to reflect in your argument, in your speaking before the court. And also, see, suppose if I take an example of 10 judgments under Hindu Marriage Act. If you read 10 judgments under Hindu Marriage Act, and now there are more than 25 high courts along with the principal benches in our country, with all the high courts. Now it is the Odisha High Court judgment, Hindu Marriage Act, one judgment you read. One judgment you read from the Kolkata High Court, one judgment you read from Delhi or Bombay High Court. If this way, even if you read 10 judgments under Hindu Marriage Act, trust me, you are going to understand the language of the court, also the sections applied, the points taken by the petitioner's advocate, the point taken by the respondent's advocate. If it is a criminal matter, point taken by the prosecution, that's the prosecutor, public prosecutor जो question पूछता है. Also, the points taken by the accused advocate. One of my junior today asked me, how do I prepare cross examination? Now, the easiest thing I would say to prepare for cross examination, if you get a case which is an accident case. Now, if it is an accident case, find out 10 judgments of accident of similar type of the same section applied. Whether lost or won, doesn't matter. What is the point taken by? What is the question asked? Now, if it is an accident case, what we will see? Whether there was a signal, what was the speed of the car or the vehicle, if it is a motor, other than the car, any vehicle, whether there was zebra crossing, whether there was red signal, green signal, whether person there were witnesses around, whether the complete that road, which is regular road, it is a highway. There are judgment which says highways are not meant for crossing for the pedestrian people. Now these are also judgments. So even if we take a simple accident case, here also we will know how to cross examine. The key lies in the reading of the judgment. So we go to our next part of the session, that is reading of the judgment. Is Soumya there?
Yes, ma'am, I'm here.
Soumya, keep on your video on. Please start reading. I'll share the judgment. Just a minute.
Yes, ma'am.
आपका वीडियो ऑन कर दीजिए मैडम.
Ma'am, actually there are two devices. My video is on.
Hello.
Yes, ma'am, my video is on.
Okay. Just a minute. Just a minute. I'll share Sarla Mudgal case. This is a Supreme Court case. Srimati Sarla Mudgal, President of the Union of India of 1995. Very interesting case. We'll be reading a part of the same today. Soumya, can you see this? There are this blue marking.
Ma'am, I can see the Word document.
These are 4 petitions.
I can see the Word document where it's written and in the matter of appeal against the judgment.
Wait. Just a minute. Now can you see this?
Yes, ma'am.
Start reading. These are the 4 petitions under Article 32. You can start from it.
These are the 4 petitions under Article 32 of the Constitution of India. There are 2 petitioners in writ petition 107989. Petitioner 1 is the President of Kalyani, a registered society which is an organization working for the welfare of needy families and women in distress. Petitioner 2, Meena Mathur, was married to Jitendra Mathur on February 27, 1978. 3 children, 2 sons and a daughter, were born out of the wedlock. In early 1988, the petitioner was shocked to learn that her husband had solemnized second marriage with one, Sunita Narula, alias Fatima. The marriage was solemnized after they converted themselves to Islam and adopted Muslim religion. According to the petitioner, conversion of her husband to Islam was only for the purpose of marrying Sunita and circumventing the provisions of Section 494 IPC. Jitendra Mathur asserts that having embraced Islam, he can have 4 wives, irrespective of the fact that his first wife continues to be Hindu. Rather, interestingly, Sunita alias Fatima is the petitioner in writ petition 347 of 1990. She contends that she, along with Jitendra Mathur, who was earlier married to Meena Mathur, embraced Islam and therefore got married. A son was born to her. She further states that after marrying her, Jitendra Prasad, under the influence of her first Hindu wife, gave an undertaking on April 28, 1988, that he had reverted back to Hinduism and had agreed to maintain his first wife and 3 children. Her grievance is that she continues to be Muslim and being maintained by her husband and has no protection under either of the personal laws. Geeta Rani, petitioner in writ petition 424 of 1992, was married to Pradeep Kumar. According to Hindu Rights on November 13, 1988, it is alleged in the petition that her husband used to maltreat her and on one occasion gave her so much beating that her jawbone was broken. In December 1991, the petitioner learned that Pradeep Kumar ran away with one Deepa and after conversion to Islam married her. It is stated that the conversion to Islam was only for the purpose of facilitating the second marriage. Sushmita Ghosh is another unfortunate lady who is petitioner in Civil Writ Petition 509 of 1992. She was married to G.C. Ghosh according to Hindu rights on May 10, 1984. On April 20, 1992, the husband told her that he no longer wanted to live with her and as such she would agree to divorce by mutual consent. The petitioner was shocked and prayed that she was her legal wedded wife and wanted to live with him and as such the question of divorce did not arise. The husband finally told the petitioner that he had embraced Islam and would soon marry one Vinita Gupta. He had obtained a certificate dated June 17, 1992 from the Qazi indicating that he had embraced Islam. In the writ petition, the petitioner was further prayed that her husband be restrained from entering into second marriage with Vinita Gupta. Marriage is the very foundation of the civilized society. The relation once formed, the law steps in and binds the party to various obligations and liabilities thereunder. Marriage is an institution in the maintenance of which the public at large is deeply interested. It is the foundation of the family and in turn of the society without which no civilization can exist. Till the time we achieve the goal, uniform civil codes for all the citizens of India, there is an open inducement to a Hindu husband who wants her to enter into marriage while the first marriage is subsisting to become a Muslim. Since monogamy is the law for Hindus and Muslim law permits as many as 4 wives in India, errant Hindu husband embraces Islam to be circumvent the provisions of the Hindu law and to escape from penal consequences. The doctrine of indissolubility of marriage under the traditional Hindu law did not recognize the conversion would have the effect of dissolving a Hindu marriage. Conversion to another religion by one or both the Hindu spouses did not dissolve the marriage. It would be useful to have a look at some of the old cases on the subject. In Rama Kumari 1891, Calcutta 246, where a Hindu wife became convert to the Muslim faith and then married a Mohammedan, it was held that her earlier marriage with a Hindu husband was not dissolved by her conversion. She was charged and convicted of bigamy under Section 494 of the IPC. It was held that there was no authority under Hindu law for the proposition that an apostate is absolved from all civil obligations and that so far as the matrimonial bond was concerned, such a view was contrary to the spirit of the Hindu law. The Madras High Court followed Ramakumari in the Budansa versus Fatima 1914 IC 697. In Gul Muhammad versus Emperor AIR 1947 Nagpur, 121, a Hindu wife was fraudulently taken away by the accused, a Mohammedan who married her according to the Muslim law after converting her to Islam. It was held that the conversion of the Hindu wife to Mohammedan faith did not ipso facto dissolve the marriage and she could not during the lifetime of a former husband enter into a valid contract of marriage. Accordingly, the accused was convicted for adultery under section 497 of the IPC. In Nandi, Zainab versus the Crown, ILR 1920, Lahore 440, Nandi, the wife of the complainant, changed her religion and became a Mussulman and thereafter married a Mussulman named Rukan Din. She was charged with an offence under section 494 of the Indian Penal Code. It was held that the mere fact of her conversion to Islam did not dissolve the marriage, which could only be dissolved by a decree of court. Emperor versus MT Ruri, AIR 1919 Lahore 389 was a case of the Christian wife. The Christian wife renounced Christianity and embraced Islam and then married a Mohammedan. It was held that according to the Christian marriage law, which was the law applicable to the case, the first marriage was not dissolved and therefore subsequent marriage was bigamous. In India, there has never been a matrimonial law of general application. Apart from the statute law, a marriage was governed by the personal law of the parties. A marriage solemnized under a particular statute and according to personal law could not be dissolved according to another personal law simply because one of the parties had changed his or her religion. In Sayyida Khatun at the rate A.M. Obadiah versus M. Obadiah 94 CWN 745 Lodge J. Speaking for the court held as under, the parties were originally Jews bound by the Jewish personal law. The plaintiff has since been converted to Islam and may in some respects be governed by the Mohammedan law. The defendant is not governed by the Mohammedan law. If there were an Islamic country where the Mohammedan law was applied to all cases where one party was a Mohammedan, it might be that plaintiff would not be entitled to the declaration prayed for. But this is not a Mohammedan country and the Mohammedan law is not the law of the land. Now, all my opinion is it's the law of India. Then that when any person is converted to Islam, the Mohammedan law shall be applicable to him in all his relationships. I can see no reason why the Mohammedan law should be preferred to the Jewish law in a matrimonial dispute between a Mohammedan and a Jew, particularly when the relationship with a marriage via marriage was created under the Jewish law. As I stated in a previous case, there is no matrimonial law or of general application in India. There is a Hindu law for Hindus, a Mohammedan law for Mohammedans, a Christian law for Christians, and a Jewish law for Jews. There is no general matrimonial law regarding mixed marriages other than the statute law, and there is no suggestion that the statute law is applicable in the present case. It may be that a marriage solemnized according to Jewish rites may be dissolved by the proper authority under Jewish law when one of the parties renounces the Jewish faith. It may be that a marriage solemnized according to the Jewish rites may be dissolved by the proper authority under Jewish law when one of the parties renounces the Jewish faith. It may be that a marriage solemnized according to the Mohammedan law may be dissolved according to the Mohammedan law when one of the parties ceases to be a Mohammedan. But I can find no authority for the view that a marriage solemnized according to one personal law can be dissolved according to another personal law simply because one of the two parties has changed his or her religion. Sayyida Khatun's case was followed with approval by the Ladin J of the Bombay High Court in Rubaza Khanum versus Khudad Bomanji Irani, 1946, Bombay Law Reporter, 1864. In this case, the parties were married according to Zoroastrian law. The wife became the Muslim, whereas the husband declined to do so. The wife claimed that her marriage stood dissolved because of her conversion to Islam. The learned judge dismissed the suit. It would be useful to quote the following observations from the judgment. We have therefore this position. British India as a whole is neither governed by Hindu, Mohammedan, Sikh, Parsi, Christian, Jewish or any other law except a law imposed by the Great Britain under which Hindus, Mohammedans, Sikhs, Parsis and all others enjoy equal rights and the utmost possible freedom of religious observance, consistent in every case with the rights of other people. I have to decide this case according to the law as it is, and there seems in principle no adequate ground for holding that in this case Mohammedan law is applicable to a non-Mohammedan. Do then the authorities compel me to hold that one of the spouse can, by changing his or her religious opinions or purporting to do so, force his or her newly acquired personal law on a party to whom it is entitled alien and who does not want it. In the name of justice, equity, and good conscience, or in more simple language is common sense, why should this be possible? If there were no authority on the point, I personally should have thought that so monstrous an absurdity carried its own refutation with it. So extravagant are the results that follow from it. For it is only the question of divorce that the plaintiff contention affects. If it is correct, it follows that a Christian husband can embrace Islam and the next moment three additional wives without even the consent of the original wife. Against the judgment of
Wait. Thank you so much. Now, this is Sarla Mudgal judgment of Supreme Court. If you read this judgment, you will be understanding that previously what happened used to happen before this judgment was pronounced by the Honorable Supreme Court. Any person who was not Muslim, if he wanted to get another wife or say, do second marriage, he used to convert or embrace Islam or convert to the Islam, and because he became a Muslim thereafter, he used to legally wed another 3 ladies. Now this was an injustice to a lot of women. So a lot of petitions were filed across the countries, also in the Supreme Court also. In Sarla Mudgal case and all other petitions were combined, and the Supreme Court came heavily on this, that a person who goes and embrace another religion, his marriage cannot be dissolved just because he has married another lady. Secondly, a person a husband who marries another lady, it will be an injustice to a first wife because she has not changed her religion, and a religion which has been accepted by the husband cannot be forced upon that lady to that she should accept the husband's religion. Now here what is today, the mischief husband is to play, they is to embrace this Islam, and then their second marriage is to be legal. Now if we have read the judgment properly, while Soumya was reading, there is section 494. Now under Indian Penal Code. Now when you read section 494 Indian Penal Code, it is about the bigamy. Any man or any woman, it applies, it is gender neutral. Any man or any woman who marries during the lifetime of that the spouse is an offense because the marriage is surviving, other than the person who is professing the Islam religion. Now all the other people, they were not allowed to have a second marriage, because if you see it in 1955 we have a Hindu Marriage Act. If you meet any people before 1955, if they are alive now, they would be having second marriages. It was not illegal or something like that. Hindus were even allowed second marriages. But after this judgment and after 1955 Hindu Marriage Act, the Hindu, there will be monogamy. The person cannot marry second time without divorcing his first wife. Now here in Sarla Mudgal judgment, the court pronounced, Supreme Court, that even if you profess only for the purpose of, if you are accepting religion, other religion, only for the purpose of defeating your wife's rights as a wife, and only for the purpose of marrying another lady, then your religion acceptance is not legal. It will not be a valid conversion. So always remember, only marry for the purpose of marrying another lady. If a person converts to another religion, that is Islam, it will not be acceptable. So in a way, this is a very revolutionary judgment, and those who are coming to this profession should know this judgment and try to, we have read only part of the judgment because there is a paucity of time. So kindly, I will be putting the link in the all the groups, ABC, read it. And if you read the judgment, you will also know 494, the benefit of reading the judgment. You know all the laws. There are laws for Jews also. There are laws for Parsi also. There are different laws for Christians also. And for Hindu, the Hindu Marriage Act. So always remember, when you read a judgment, you get all this knowledge also. You also know 494 bigamy, that is Indian Penal Code. So by reading the judgment, you get the knowledge also. Your legal language improves. Secondly, you also know what is the law of the land where we are residing. So this is one judgment I would request everybody to read. Now we move to another third part, that is about learning. In criminal matters, either the accused is acquitted or convicted. If it is acquitted, well and good. But if it is convicted, the person goes to jail. Now, once the person is convicted for 2 years, 3 years, 5 years, or lifetime, what happens? Can he come back to the family? What will happen? Now everybody will answer me here. Simple answer, as a layman we will say, जब उसकी सजा खत्म हो जाएगी वो घर आ जाएगा. No, this is not true. There is a provision in the jail manual and also in the jail laws where the person convicted can come back to the home for some limited period of time. नाउ देर आर, जैसे हम लोग को स्कूल से छुट्टी मिलती है, समर वेकेशन, विंटर वेकेशन, वैसे उसी टाइप के आप इसको अंडरस्टैंड कर सकते हैं। उसको फरलो और परोल दो लीव है। एंड यू मस्ट हैव रेड इन दी, परोल पे छूट गया है, परोल पे छूट गया है, पेपर में, न्यूज़पेपर में आप, तो फरलो लीव यू विल रेयरली हियर। नाउ डिफरेंस बिटवीन परोल एंड फरलो लीव, दे आर बोथ आर लीव, दोनों को जेल से छुट्टी मिलती है, बट नॉट इन एवरी केसेस, देर आर सम jail rules and regulation, but it is given to every convicted person. Now when a person is convicted, there is a furlough leave. Every year he has given a limited period of leave. It may be 7 days or a week in 6 months, or 2 weeks in a complete year. He is given this leave to go to his family. It may be for the purpose of that, see, if a person is convicted 14 years and if children are small, they have not committed a crime, law says he should keep in touch with the society. After 14 years he comes suddenly out of the jail, his family may not accept him. There may be other reasons also, there may be other family settlements also which he have to do, he has to make provision for his family also. So law allows the furlough leave every year or every 6 months. It depends on, in Bihar we will have different rules and regulation of jail, how many times furlough leave is granted. In Mumbai, that is in Maharashtra, we will have different, because the jail authorities will have their different rules every in our country. But at the most, what you have to do, you have to make an application to the jail authorities, and if they accept, then fine. If they do not accept, it also depends on your behavior in the jail, convict's behavior in jail, his attitude, how he treats other convict people, how he works. उसको कुछ काम भी दिया जाता है पक्के कैदियों को, जो कन्विक्ट हो जाते हैं उनको, जो अंडर ट्रायल होते हैं उनको काम नहीं दिया जाता, लेकिन जब दोज आर कन्विक्ट उनको कुछ काम भी दिया। हाउ ही बिहेव, हिज बिहेवियर, हिज डेमेनर इन जेल आल्सो डिपेंड्स। तो ऑलवेज रिमेंबर कि फरलो लीव उसका अधिकार है, उसका राइट है कन्विक्ट का, एक्सेप्ट फॉर सम रीजन वेयर द जेल अथॉरिटी कैन रिफ्यूज। नाउ देयर इज अनदर काइंड ऑफ लीव, दैट इज परोल। नाउ इन परोल लीव में क्या होता है कि देयर इज एन इमरजेंसी, समझो उसकी वाइफ को कैंसर हो गया and she is in the last stage, or there is nobody to make a provision for her to take hospital, to do operation, और उसके बेटा या बेटी की शादी है, कोई भी नहीं है उस समय, for that also the parole leave can be granted. His parents are sick, now parole leave ऐसे समय में आप जेल अथॉरिटी से ले सकते हैं। There is one more difference in parole and furlough leave. परोल ऐसा होता है कि जब इमरजेंसी में मिलता है तो आपका सेंटेंस है, समझो आपको 2 साल के लिए कन्विक्शन हुआ है, and if you are going on parole for 15 days, your 15 days you have to complete when you come back. So if it is for after in 2 years, if you have gone for parole leave for 30 days, 15 दो टाइम पे, तो 30 days आपको वापस कन्विक्शन में आपको काउंट कराना पड़ेगा, आपको वो you have to undergo that. But in furlough leave में if you are go 7 days on the leave, तो उसका अधिकार, that's what I said, it is the right. अगर if he goes for 7 days, that will be complete like छुट्टी है, उसको वो that will not be counted, so it will be subtracted or deducted from his conviction period. So he will not be for that 7 days, he will not be asked to go through that same 7 days plus. But in parole leave, if he goes for emergency leave, that he has to undergo the imprisonment for the whatever period in parole he has gone out of the jail. So that is the difference. It is very basic. For parole and furlough leave, you have to go to, अगर कोई client आपके पास आता है तो you have to go to the jail authorities, make an application, or a competent authorities, जैसा स्टेट गवर्नमेंट होगा, जहां जैसे रूल्स एंड रेगुलेशन बने होंगे, और उसके बाद इफ दे रिफ्यूज, the only remedy lies to the high court, that you file a writ petition. If high court agrees, fine. If high court do not give in favor of your clients any decision, you can always approach the Supreme Court by way of special leave petition. So this was all parole and parole leave. I also got a video recorded on the same. I'll ask Vandana to put in the group. So this was all about today. If you